We have to deal with this issue with escrow deposit and earnest money deposits so often. I want to help everyone understand what it means to put up escrow, what the requirements are, and then unfortunately the path to either getting yours back or canceling or seeking escrow. So first and foremost, a lot of people misunderstand what earnest money is. They're like, well, I put up my money as a deposit. Once you put up an earnest money deposit, it's nobody's money anymore. It is the transaction's money. It's not your money anymore. The transaction owns that money. You don't anymore. There are way too many people, kind of the glue that kind of keeps everything together. There are too many people that misunderstand the path to getting their deposit back. So first and foremost, the majority of the time that an escrow deposit is going to be returned or provided to one party or another, it is going to require both parties to sign off on it. I'll give you an example. You put up an earnest money deposit and you do your inspection, and during your inspection period, you cancel. Now, the likelihood is if it ever turned into a dispute, you would end up getting that back, or there would be some sort of legal process, or a board of realtors would get involved. The reality is that title companies typically release escrow deposits when both parties agree. Now, what ends up happening is, in that instance, you're canceling, you're in your inspection period, you want your money back. The real estate agent is in an advisory role. We can't release escrow. For the most part, real estate agents and brokers don't hold escrow. They are allowed to, but I can tell you as a standard of practice, because the liability that comes along with it, most don't want to. Most will not hold escrow because they don't want to get stuck into these disputes and litigation. They allow the title companies, or they encourage title companies to hold the escrow, or attorneys to hold the escrow. So when there is a disagreement, real estate agents really can't fix anything. You can't call and scream at a real estate agent and say, make them sign it, because a buyer and seller, under their own will, have to sign a release so that the title company or attorney can release it. If one of those parties doesn't want to do something, the real estate agent doesn't have any authority to force them. We can encourage them, we can give them advice, we can explain and say, hey, you're gonna end up losing, and they may pursue you for attorney fees, and or you need to be honorable. We can certainly encourage and give them advice and tell them about our experience, but we don't have a right to tell them or force them to sign anything. We get people all the time where a deal will cancel, the seller and buyer disagree, and people are calling the real estate agents and screaming at them, telling them to get them their money back. Well, it's not your money. It's the transaction's money, number one. And number two, we have no role in it. We can't do anything except talk to people. We can't sign it away. So if you have situations where a buyer or seller doesn't agree with the other party on the release, and it's very common, what ends up happening is a dispute happens, and the parties can talk to their own lawyers. The parties can end up going to mediation to try and resolve it. Now, most of the times the deposits are small enough to where it just doesn't make sense to turn it into this dispute and cost either party money when they're likely to lose. And that's where the real estate agent will step in and encourage and maybe give some advice. We'll have people call and threaten us. We're going to take you to court because they're not giving me my deposit back. We don't have anything to do with it. We can't make them sign something, okay? They don't agree to it. They disagree. And so you're just going to have to go through the process. So deposits, they're not your money anymore. They're not the seller's money. They're not the buyer's money. They're the transaction's money. And if both parties sign off on it, then it's an easy path to getting the deposit back should a transaction cancel. Earnest money held in deposit by a title company or an attorney typically, okay? Real estate agents in our area do not want to hold it, all right? So when a deal cancels, both parties agree, they sign a form, and the escrow goes back. If both parties don't agree, then there's a process to handle that. And the process to handle that isn't one or the other parties yelling and threatening and expecting the other party to move. You're just going to make it worse. If there's a disagreement, there's a process that has to be followed, and that's just the way that it works. Even though you may believe you have a right to cancel the contract based on the terms of the contract, there's a process that has to happen that if the other party doesn't agree, then you have to go through a process. There's no way for you to get that money back until or unless there is a court hearing or a mediation or a third party review like a board of realtors if both parties can't agree to it. So hopefully that is helpful.